Mr. Adams.
Grateful. My lady, my lords, the fundamental submission of the respondent is that a boundary demarcation agreement, properly understood, defines the boundary as from the time of the original dividing or route conveyance. When one owner comes to sell their property, they cannot transfer more than they own, and therefore the boundary demarcation agreement effectively binds a purchaser without more. Before the short adjournment, I set out the structure of the respondent's submissions. I'll address first questions of principle before addressing the second part, the policy considerations. Then as a third part of my submissions, I'll address the third P, the question of precedent. I'll then ask Ms. Cross to address the court on the question of procedure in relation to ground 2. On the first point of principle, I'm going to start with a brief taxonomy of boundary agreements. Then I'll turn to explain why they're binding as between the parties, before turning to why they're binding as between successors in title, and finally then explain why there is no requirement for notice. On that
or knowledge.
Knowledge or notice, the words are used interchangeably in the appellant's case, but neither in my submission is required, or for that matter, registration. What then is meant by a boundary agreement or a boundary demarcation agreement? Starting with the case of Nielsen and Poole, the judgment of Mr. Justice McGarry, at page 52 of the authorities bundle, Mr. Justice McGarry identifies two types of boundary agreement. If one looks to the sidelined text towards the bottom hole punch, the paragraph starting now, a boundary agreement may constitute.
So which page are you on?
Page 52 of the authorities bundle.
Yeah.
The paragraph starting now, a boundary agreement.
Yeah.
Now, a boundary agreement may constitute a contract to convey land. The parties may agree that in return for a concession by A in one place, straightening the line of division, B will make a concession in another place. That's the first type of boundary agreement, a mutual concessions exchange of land. But there's another type of boundary agreement that does no more than identify on the ground what the documents describe in words or delineate on plans. Nothing is transferred, at any rate consciously. The agreement is to identify, not to convey. In such a case, I do not see how the agreement can be said to constitute a contract to convey land. That's a type 2 boundary agreement, a boundary demarcation agreement. And that's what we're concerned with in this case. Mr. Justice McGarry identifies two presumptions that also operate in the case of boundary agreements. The first is in the following paragraph, that a boundary agreement will be presumed to fall into the latter category. And the second is identified on the following page 53. In the second full paragraph starting there, may, towards the bottom of that paragraph, in short, in my judgment, a boundary agreement is presumed not to convey land. The presumption may be rebutted, but unless it is, the agreement is not registrable, and to point to circumstances of doubt or uncertainty is not to rebut the presumption. Stepping back to page 52, my learned friend's right to say that Mr. Justice McGarry looked to the case of Penn and Lord Baltimore for inspiration. for this conclusion. The inspiration in the quoted paragraph at the bottom of page 52 is to say that such a settlement of boundaries amounts to an alienation is not the true idea of it, or if fairly made without collusion, which cannot be presumed, the boundaries so settled are presumed to be the true and ancient limits. There's a point Malone and Friend raised about Penn and Baltimore, and I don't propose to take the court back to the passage at page 10 of the authorities bundle that says that Penn and Baltimore is concerned only with remedies in personam and not in rem. When reading that paragraph, one has to remember that that was a case decided by the Court of Chancery before the fusion of the courts of equity and common law. And what it's talking about is the jurisdiction of that court to grant a remedy of specific performance, which is a remedy that acts in person, rather than being able to grant proprietary remedies in rem. It's not talking about the effect of an agreement as to boundaries. Building on the inspiration of Penn and Baltimore, at page 54 of the authorities bundle, the paragraph marked with a dark line and starting I may add. Mr. Justice McGarry dealt with an argument that this contention was that once the boundary agreement was made, it superseded the conveyance insofar as the conveyance defined the boundary. He says, yet what the agreement did was merely to establish on the ground by agreement what it was the conveyance showed. A boundary agreement that merely demarcates is, I think, an agreement that is ancillary to the conveyance. It does not supersede it. That is a fundamental point about a Type 2 boundary demarcation agreement. It is an agreement that defines on the ground what an unclear route conveyance conveys. The point was raised this morning in relation to the comment by Mr. Justice McGarry on page 53 of the authorities bundle about adverse possession or limitation. This is Mr. Justice McGarry positing the scenario contemplating a Type 1 agreement where there is a disposition of land. And he's contemplating at that point the possibility of adverse possession interfering. Where there's an unclear route conveyance, which is clarified by a boundary agreement, there is no conveyance of land and no room for the principles of adverse possession to operate. In the more recent case in this court of Joyce and Wrigley, which appears at tab 8 of the authorities bundle, Mr. Justice McGarry's two-part classification was considered further. In the judgment of Lady Justice Arden, as she then was, the relevant part of which can be found at page 84 of the authorities bundle, she adopts the classification set out in Nielsen and Poole. Paragraph 26, page 84, she says, with consummate clarity of expression and understanding of ordinary life, Nielsen and Poole, Mr. Justice McGarry analysed boundary agreements into two different types. Those that constitute an exchange of land and those by which the parties merely intend to demarcate an unclear boundary referred to in title documents. In that case, the Court of Appeal was grappling with a potential distinction on the facts concerning Mr. Joyce's cherry tree. That is apparent at page 86 of the authority bundles and in paragraph 32. when the Joyces and Mr. Wrigley reached their agreement, there was a small conscious transfer of land because Mr. Wrigley thought that he was giving up a small triangle of land around Mr. Joyce's cherry tree. Lady Justice Arden addresses this point by saying that, and this is at the end of paragraph 32, I do not consider that Parliament, which after all had enacted section 2, that's of the 1989 Act, against the background of Neilson and Poole, could have intended section 2 to apply to transfers of land pursuant to boundary agreements of Mr. Justice McGarry's latter type, demarcating agreement, simply because a trivial transfer or transfers of land were consciously involved. Therefore, within the type 2 demarcating boundary agreement, there might be two types of agreement. First is an agreement where the parties intend only to demarcate and do not consciously transfer any land. And the second is an agreement where the parties intend to demarcate but consciously make trivial transfers of land. Lady Justice Arden adds a third presumption to the two presumptions identified by Mr. Justice McGarry in Neilson at paragraph 33, which is, it is presumed unless the contrary is shown that any transfer of land affected by a boundary agreement of the demarcating kind is trivial. Lord Justice Thorpe, who gave a short concurring judgment in Wrigley, Sir Martin Norse, who gave a short concurring judgment in Wrigley, which is found at page 88 of the authorities bundle. At paragraph 45, agreed in the outcome. There are two ways of looking at it. Either the agreement was one whereby, in fact, it was agreed that land belonging to one should thenceforth belong to the other within the second passage I have read from Mr. Justice McGarry's judgment, or the de minimis principle applies. So Sir Martin Norse viewed that distinction, that triviality distinction drawn by Lady Justice Arden as an application of de minimis non curat lex. What that means is trivial matters are treated by the law as being nothing at all. So again, a trivial or de minimis transfer of land pursuant to a boundary demarcation agreement is not regarded as a transfer of land because it is de minimis. Therefore, that sits with the rationale I've expressed and explained in relation to Neilson and Poole, that what a type 2 boundary demarcation agreement is doing is agreeing the original effect of the route conveyance without any transfers of land involved.
Would you accept that from a purist point of view, there is perhaps some difficulty with that rider introduced by Lady Justice Arden? Because if you're consciously transferring land and you are therefore consciously not using the machinery laid down by Parliament as to how you have to do that, namely by something in writing, that does have a certain tension, doesn't it, with the position where you are simply making clear something which ex hypothesized from the beginning has not been clear, which is what the precise line of a general boundary is.
If it weren't for the de minimis principle, it would be problematic to purists.
Yeah.
But because when the de minimis principle applies, the law regards the thing as no thing at all, a trivial transfer of land is not a transfer of land, and therefore there is no tension there.
It is a conscious transfer. You say it's so trivial, it's to be treated as not a transfer. But what is the effect then in relation to who owns what?
Well, the agreement still defines
the boundaries,
but as ancillary to the original conveyance that split the land into separate ownership.
And it does so effectively in law, because if the whole thing were ineffective, obviously it would be pointless. So the law, this is where it gets difficult. I mean, it may be a small area around the cherry tree, but the cherry tree might have mattered a lot to Mr. Joyce, and he ends up getting a bit of land which includes it, which he didn't own beforehand, or at least arguably didn't own beforehand.
That's true. The next case I'll come on to, which is Natalie, does involve a further consideration of the de minimis principle, and it shows that the courts are alert to police the distinction between what is truly de minimis and what is not. And that is something that the courts are well able to adjudicate on.
Before you do, can you just... The two possibilities envisaged in 45 of Sir Martin North's judgment are either it's the de minimis principle or it's within that passage from Mr. Justice McGarry's judgment. But that passage at page 919, he starts with the agreement being different from another boundary. Then he says the agreement would have been an agreement whereby in fact it was agreed that land belonging to one should thenceforward belong to the other. So he is dealing there with a case where there is a transfer of land, isn't he? And yet he goes on to say that's still not a conveyance. It's not registrable because it's merely demarcating. But he seems to be blurring his own two distinctions there.
There is, in the case of Yeats and Line, which is referred to in Malone Frenska's an argument which doesn't appear in the authorities bundle, that's a High Court decision. That case concludes that there are two categories. One where there's a demarcating purpose and no conscious transfer, and a second category where there's a demarcating purpose and a conscious trivial transfer. That suggests that in the first category, you could have a non-trivial transfer, but still come within the exception. Now, for the purposes of this case, it's not necessary to resolve that because we're dealing with the purest form of boundary demarcation agreement, where the judges below found that none of the three presumptions were rebutted. Therefore, there was no intention to transfer land and there was no evidence of a transfer in fact occurring. I appreciate there's a conceptual difficulty in the first subcategory as to whether, if the parties had no demarcating purpose, but it's inadvertently involved a non-trivial transfer of land, the question might arise as to whether that is a boundary demarcation agreement or not. The authorities at Court of Appeal level, if Yeats and Line is correct in how it's interpreted them, suggest that it does fall within the doctrine. But it's not necessary for the resolution of this appeal to decide whether that's the case or not. Turning then to Natalie and Abid, which is tab 11 of the authorities bundle. This is again the Court of Appeal, and it's a judgment of Lord Justice Briggs, as he then was. At page 115 of the authorities bundle, paragraph 28, Lord Justice Briggs confirms the two-part distinction seen in Joyce and seen in Nilsson beforehand. He then finds, in relation to the particular agreement found by the judge in that case, that it fell down on all of the requirements. So first of all, there was no, in paragraph 30, there was no uncertainty as to the boundary in the route conveyance. It was an extremely clear plan, one of the clearest that the surveyor had ever seen. A rare thing, perhaps. But given the context of a tightly packed East London row of houses, perhaps not entirely surprising, because the boundaries might have mattered to the original parties. At page 116, paragraph 31, it didn't have a demarcating purpose. And then thirdly, in the same paragraph, the land transferred was not in the context trivial. Triviality or de minimis is context dependent, as Lord Justice Briggs makes clear. What is trivial in a field in the countryside might be more than trivial in the context of dense inner city housing. And then the fourth point of paragraph 32, there is no consideration for the agreement, and he explains the consideration that's usually applicable in a type 2 agreement, which is each way by the substitution of certainty for uncertainty as to the boundary, and the relief of both neighbours from the risk of future disputes. The decision in Natalie shows that the courts are well able to identify and police the boundaries of a true boundary demarcation agreement from one which falls outside the doctrine. And therefore this isn't the loose doctrine or concept that is presented by the appellants. It's a tightly defined concept with clear parameters in which it can operate. The same might be said for the judgment in this case. District Judge Mills, in determining the preliminary issue, determined that there was a boundary demarcation agreement. And given the constraints on time, I won't take your lordships to the judgment, but the key parts are in the core bundle, pages 106 to 108. And to pay particular attention to paragraphs 13, 21 and 22.
Sorry, 13?
13, 21 and 22.
Thank you.
Why then does a boundary demarcation agreement, a type 2 boundary demarcation agreement, bind the original parties? Well, first of all, as considered by Lord Justice Briggs in Natalie in the paragraph we've just seen, it's binding as a contract. There's consideration, substitution of certainty for uncertainty and the avoidance of future disputes. We know from Joyce and also Natalie, at paragraph 28 on the preceding page, that the agreement is not subject to any formality requirements applying to dispositions of land generally. Lord Justice Briggs refers to the 1925 Act, which is no doubt a reference to section 52, which requires a conveyance of land to be by deed, and the 1989 Act, which relates to contracts for the disposition of interests in land, which are required to be in signed writing. Finally, the agreement itself is sufficient to bind the parties to it. There is no need for the something else posited by the appellant. In Joyce and Wrigley, relevantly at page 87, behind tab 8 of the bundle, Lady Justice Arden, at the conclusion of paragraph 36, says in the concluding sentence of that paragraph that the agreement would have been effective according to the principles of proprietary estoppel. But she didn't posit that as a necessary requirement. That was merely an observation that the alternative would apply. Sir Martin Norse, page 88, paragraph 45, said that it was unnecessary to consider that section 2.5 of the 1989 Act and the decision of this court in Yaxley and Gotts. So that's concerned with proprietary estoppel and constructive trusts. So in order for the agreement to be binding, it wasn't necessary to look to constructive trust or proprietary estoppel principles. Lady Justice Arden was satisfied that they would have been met on the facts of that case, but it wasn't necessary. The same can be said in the case of Stevenson and Johnson. The relevant part of the judgment of Mr. Justice Bennett is at page 75. page 58 at the very top of the page, my finding of an agreement thus renders it unnecessary to move on to the other grounds of appeal relating to estoppel. Similarly, Lord Justice Hill, Authorities Bundle, page 77, paragraph 72. He agrees with Mr. Justice Bennett that it is neither necessary nor appropriate to go on to deal with the estoppel argument raised. So a true boundary demarcation agreement, a Type 2 agreement, binds the parties to it without more. There is no need for an estoppel, constructive trust, or for that matter, adverse possession, anything of the sort. Why then does it bind successors in title? In this regard, I would simply adopt the reasoning of the authors of Roth and Roper on registered conveyancing, which appears at tab 21 of the bundle, page 229.
Sorry, which tab?
It's tab 21,
Thank you.
and it's page 229. In the first part of the paragraph 5.020, the authors explain what a boundary agreement is by reference to the authorities to which the Ladyship and your Lordships have just been referred. The second highlighted paragraph towards the bottom of the page then explains the principle I set out at the outset. So the boundaries are presumed to be the true and ancient limits. It's ancillary to the root conveyance. They then said it follows that a boundary demarcation agreement is effectively binding, in inverted commas, on successors. I'll say binding is in inverted commas because the way that binding is usually used in the sense of estates or interests affecting land is to describe the effect of some ancillary interest to the main legal estate. So, for example, a tenancy or a charge or an easement. And we're concerned about whether those secondary interests bind purchasers. In this sense, we're not talking about binding in that sense of the word, hence the inverted commas. Its effect binds successors in title because it defines the extent of the parcels for the purposes of the root conveyance.
Sorry, can you just say that again? The effect is that it binds successors because it defines...
It defines what the land always has been since the original dividing conveyance. They go on to say a legal boundary does not move just because the land is subsequently conveyed or transferred.
Now, what would be the only thing that could be said against that is if it's only binding as a matter of contract, it means that the two joining landowners for themselves know where each party's piece of land ends. But when either of them comes to sell, that agreement's not binding. So you revert to the position of uncertainty that was the case before you made an agreement. That would be the only consequence of it not binding.
That would be the alternative analysis, yes. So the appellant, if correct, would have the position that on a conveyance, the boundary agreement falls away, and the successor and the predecessor, the original party of the neighbouring land, revert to the uncertainty of the original conveyance. In the context of unregistered conveyancing, the Latin maxim nemo dat quod non habet would apply. That's the point that a person can not convey more than they own. So the vendor cannot transfer to a purchaser something which they themselves did not own. If the appellant's construction is right, there's a difficulty explaining if in an agreement, a boundary agreement between A and B as to where the boundary is, a conveyance by B to C, to which A is no party and has no control over it, can affect the extent of the property owned by A.
Sorry, I said that. You're saying the difficulty is to explain how an agreement between A and B.
Yeah. So A and B enter a boundary demarcation agreement agreeing where the boundary is of the purely demarcating kind. B then sells to C. If the effect of the transfer from B to C is to mean that the boundary demarcation agreement no longer has any effect, A's property rights are affected by a transfer over which A is no party to and cannot do anything to prevent or affects the terms of. And that, in my submission, is problematic if the appellant's analysis is correct.
If A discovered B was about to do this, even assuming it's a purely contractual matter, presumably A could seek to restrain B from selling what A has agreed with B is A's land.
If A knew.
Yes. Yeah.
Which is a big addition. I mean, presumably would also apply if it wasn't a sale, but if it was some other form of transfer. So, for example, if B died and C inherited the land, A might have no warning that B is about to die, but would still be affected by the transfer of title to his estate and onward to his successors. So, again, it's problematic about how A's property rights can, in those circumstances, be affected by a transaction to which he has might have no knowledge and play no part. I suppose to put the problem in the converse, how is a purchaser in a better position than a vendor in that scenario?
It would be said against you, though, that it's not affecting A's rights in any way. It's just that instead of certainty, one's back to uncertainty. There's no land which is changing hands.
Yes, but A still has the loss of certainty as to the property rights, which is a thing of value. For the reasons explained in the authorities.
Yeah.
In the case of registered conveyancing under the Land Registration Act 2002, Section 58 of the 2002 Act identifies the effect of registration as a proprietor of a legal estate. So, tab 28, page 266 of the bundle. Is section 58. And subsection 1 has the effect that upon registration, the new proprietor is deemed to have the legal estate vested in him as a result of registration. But that conclusiveness is qualified by section 60, which appears at page 268. Which provides in subsection 1 that the boundaries of a registered estate shown for the purposes of the register is a general boundary unless determined under this section. And in subsection 2, a general boundary does not determine the exact line of the boundary. So whilst the register guarantees title to land, it does not guarantee title as to exact boundaries, only as to general boundaries. Turning back to Ruoff and Roper, tab 21, page 229 of the authorities bundle. In the second paragraph on that page, the authors identify two situations where, as a result of section 58, the doctrine is limited. So it said, first, where the boundary is a determined boundary and the position differs from what has been agreed. So where there's a boundary agreement under section 60, that determines the boundaries conclusively.
I'm sorry, I can't find where you are on page 229.
Second paragraph on page 229.
There is a rebuttable presumption.
Yes, so third sentence starting however.
Yes.
However, because of section 58 of the Land Registration Act 2002, the second presumption cannot operate so as to identify the current position of the legal boundary in two circumstances where the boundary involved is of a registered estate. First, where it's a determined boundary and the position differs from what has been agreed. And second, where the agreed position differs from the general boundary as shown on the title plan, and this difference is outside the scope of the general boundaries rule. But they go on to say that that's unlikely in practice to be a major limitation. Determined boundaries are very rare and the scope of the general boundaries rule is wide. The only part of the analysis of the authors of Ruoff and Roper that I disagree with is the concluding paragraph of this section, which appears over leaf on page 230 of the authorities bundle. That analyses the Joyce and Wrigley type agreement as a hybrid involving both demarcation and adjustment in the form of trivial transfers, which it suggested might need to be protected by notice on the register. But for the reason I gave earlier, the trivial transfers is an operation of de minimis. So it's not regarded as transfer at all, so it wouldn't need to be protected in the way the authors suggest. Of course, this is a case where there is no transfer found to have occurred whatsoever. Why then might there be a requirement of knowledge or notice for a purchaser? The respondents say there is no such requirement. It certainly can't be identified in any of the authorities but before the court, including, I would say, Gibson and New. We know from the principles that I've set out already that the effect of a true boundary demarcation agreement is to establish on the ground what the route conveyance shows, that it's not subject to any statutory formality requirements, and that it does not need to be registered, whether as a land charge in relation to unregistered land or by an entry in the register under the Land Registration Act 2002. It is common ground that it does not create or transfer an equitable interest. And for the reasons I've identified, it doesn't operate via the principles of estoppel or constructive trust. Of course, a purchaser doesn't need to have knowledge or notice of other matters which might be relevant to the construction of the route conveyance. So the physical features in existence at the time of that original conveyance, the conduct of the parties to the conveyance, which could include their conduct after the date of the original conveyance, are all matters which might affect the interpretation of an uncertain original or route conveyance, but which result in its definitive interpretation, whether or not the purchaser, current owner of the land, knew of those matters or not. Why then would an agreement between owners of the land require notice or knowledge on the part of a purchaser? In the respondent's skeleton argument, we point out that the appellant does not identify any legal source for this principle of notice or knowledge on which he relies. In my submission, that remains the case, despite that being highlighted by the respondents in writing. Instead, the appellant's case is based on a general appeal to fairness, or what the man on the street might perceive to be fair. That is not a clarification of precedent. It is not an argument based on principle. And any argument about fairness will be answered by the policy considerations, which I'll turn to next. It should be said that if right on ground 2 about the requirement for notice or knowledge, the problems identified with A's property rights being affected by a transaction between B and C are multiplied, because in order for A's rights to be set by the boundary agreement, those rights are then contingent on what may be a number of successive transfers of B's land, and the need for A to show in each case that the purchaser had notice or knowledge of the boundary agreement made between A to B. So if B transfers to C, who transfers to D, who transfers to E, on each occasion, A would need to show that there was notice in order for the effect of the agreement to carry down the line of transfers. In my submission, that simply can't be the right analysis of the law of boundary agreements. The policy arguments in favour of boundary agreements were first identified by Mr. Justice McGarry in the case of Nielsen and Poole, to which a lot of attention has already been paid. It's page 53 of the authority bundle, tab 5.
And it was page?
53.
Thank you.
Final paragraph. Boundary agreement is, in its nature, an act of peace, quieting strife and diverting litigation, and is to be favoured by the law. I also bear in mind that many boundary agreements are of the most informal nature, and that the penalty of failure to register an estate contract is that the agreement will be void against the purchaser. These more general conditions, I think, support me in the view that I have expressed. Those policy considerations have been repeatedly endorsed by previous constitutions of this court. Highlighting 3 of them, first at tab 7 in the case of Stevenson and Johnson, page 72 of the appeal bundle, paragraph 42, which is the judgment of Mr. Justice Bennett. Mr. Justice Bennett rejects the submission that the court should not strive to find boundary agreements by reference to that principle previously identified for Nielsen and Poole. It's also endorsed in the same judgment at page 77 of the authorities bundle in paragraph 70 and 71 by Lord Justice Pill. In tab 8, page 85, which is Lady Justice Arden in Joyce and Wrigley. And she adds to that principle at page 86, paragraph 32.
Sorry, on page 85, it's paragraph.
Page 85, it's paragraph 28. You see the two indented quotes from the judgment of Mr. Justice McGarry.
Yep.
And then page 86, there's a small supplement. It's starting with the word further in the middle of paragraph 32. To make a boundary agreement dependent on the preparation and execution of a written contract would be contrary to the important public policy in upholding boundary agreements so powerfully identified by Mr. Justice McGarry and Nielsen and Poole. I should say in the previous sentence, you also said it would be unrealistic to require the parties to execute a transfer of the land given up by Mr. Rigoli, still less that unconsciously given up by Mrs. Joyce. In both cases, the land would be quite difficult to define without the disproportionate expense of a survey. Then in Natalie and Abid, Lord Justice Briggs, tab 11 of the bundle, page 114. At the bottom of that page in what's part of paragraph 26, the second quotation from Mr. Justice McGarry, that principle is adopted. And there's an additional statement of policy which we've already seen at paragraph 32 on page 116 in the discussion of consideration, and that a boundary demarcation agreement substitutes certainty for uncertainty and relieves both neighbours from the risk of future disputes. And that, in a nutshell, is what I say is the legal policy justification for the existence of the boundary demarcation agreement doctrine. It's the substitution of certainty for uncertainty and the avoidance of future disputes.
It may not be strictly relevant, but perhaps one of the reasons why the judgment of Mr. Justice McGarry has had such a favourable press in the case law is his own eminence as a property lawyer. I mean, one can sort of almost take it for granted that if there were some fundamental property law objection to this doctrine, he, if anyone, would have noticed and articulated it. But on the contrary, it is he who sees his way to a pragmatic solution which pays adequate respect to the previous history and development of the law while producing a common sense result which can only be applauded by anyone who has any practical experience of boundary disputes.
Well, I think that's more of an observation than a question, but it's one I would entirely adopt. In a number of the occasions when the Court of Appeal has endorsed the views of Mr. Justice McGarry, they have also noted his experience, and I think in Lady Justice Arden's judgment, she talks about his immense practical experience or appreciation, I think, of the difficulties of everyday life. So I'll come on to one of the counter policy arguments ignores the realities of boundary disputes.
Was the point expressly made in his textbook over the period of time from the early 1970s onwards? Do we know?
Sorry, my lord, I didn't quite catch the question.
Was the point made in Mr. Justice McGarry's own textbook on the law of real property over the period from, I don't know when the first edition was, it was a long time ago.
I don't know the answer to that question. The current edition has only a relatively brief section on boundary agreements, which is why it hasn't been included in the authorities bundle. There's more detail provided in the works of Emmett and Roth and Roper and Holsbury's laws, which is...
the textbook was actually a joint work with William Wade. It was McGarry and Wade. I mean, he wrote his own... McGarry had a handbook on real property, but the magnum opus was McGarry and Wade.
I'm sure if it would assist the court, we can research the first edition and find out when it was and what was said.
Don't worry about that.
Turning then to the
1957. 1957.
Thank you.
Yes.
Turning then to the contrary arguments. In my submission, the appellant identifies three counter arguments as matters of legal policy. First, it's said to undermine the formality rules that Parliament's enacted, that there are alternative mechanisms for establishing certain boundaries, and there are possibilities of disputes about the existence of the boundary agreement itself. In relation to the first point, that it undermines the formality rules, this is addressed by Lady Justice Arden in Joyce and Wrigley, page 86 of the authorities bundle in paragraph 32 of her judgment. It's a passage that I've already read out for a different purpose, but the simple point is that Parliament enacted Section 2 of the 1989 Act against the background of Nielsen and Poole. It might be said equally, Parliament enacted the Land Registration Act, formalised the General Boundaries Rule, introduced provisions for determined boundaries against that background. And therefore, Parliament is taken to have known that was the underlying common law. And therefore, it doesn't outweigh the policy aim. The policy aim promoted by boundary agreements outweighs the policy aim of requiring contracts relating to land to be in writing. The same would apply to requirements of registration and so forth. In terms of the suggestion that there's different mechanisms for establishing precise boundaries, and in particular by an application of Section 60 of the Land Registration Act 2002 for a determined boundary, that point is effectively addressed in the same paragraph by Lady Justice Arden, although she's not talking about an application for a determined boundary. The points about the disproportionate expense of a survey in order for there to be a formal conveyance of land would apply equally to a boundary determination under Section 60. Section 60 subsection 3, which appears at page 268 behind tab 28, provides that the land registry can the rules can be made for determined boundary applications. So that's Section 60, subsection 3b. Rules may make provision for how the exact line of the boundary may be determined. Such rules have been made. They appear at tab 24 in the form of the land registration rules. So a formal application is required. This is Rule 118, subsection 2, in Form DB. It must be accompanied by a plan identifying the exact line of the boundary, so sufficient surrounding physical features to allow the general position of the boundary to be drawn on the Ordnance Survey map and evidence to establish the exact line of the boundary. So the process requires a formal application, a survey. Evidence is an onerous process, at least as onerous as the conveyance contemplated by Lady Justice Arden in Joyce and Wrigley. Practice Guide 40, from which the quote about doubt about the requirement for notice or knowledge is also taken, sets out the Land Registry's requirements for determined boundary applications. It's not in the bundle, and I don't propose to refer to it in detail. But, for example, one of the requirements as to a survey is that it must be to an accuracy of 10 millimetres. So applications for determined boundaries are frequently rejected. And indeed, in this case, one of the steps the two vendors took initially was to apply for a determined boundary, which was refused by Land Registry because the plan we see in the bundle didn't meet their specification. It was suggested by the Land Registry that instead they should register it as a boundary agreement. The requirements for a registration of a boundary agreement are far less exacting. They just require evidence of the agreement. So the existence of the process for a determined boundary application is not an answer, not a policy answer, to the continued existence of the determined boundary, of the boundary demarcation agreement doctrine. Then the third point is the possibility of disputes about the existence of the boundary agreement. Now, it should be remembered that in order for the boundary demarcation agreement doctrine, the type 2 agreement doctrine, to apply, you must have an uncertain route conveyance. In Nutter, Lee and Abid, we saw one of Lord Justice Briggs' reasons for rejecting the case based on the boundary agreement was that the route conveyance was perfectly clear. So there are two potential disputes here. There's a potential dispute as to the existence of a boundary agreement. The alternative, if the boundary agreement doctrine doesn't exist or apply or affect successors, is that instead the parties would have to have a dispute about the effect of a necessarily vague route conveyance. Now, the route or original conveyance is logically something that existed in an earlier point in time, was created at an earlier point in time to the boundary agreement. The factors which will assist in its construction are factors in existence at the time or shortly after the route conveyance. Therefore, the dispute about construction of a vague route conveyance is just as vulnerable to poor memories, lack of evidence, invention, all of the problems that my learned friend identifies. Indeed, in my submission, because of the logically greater passage of time, it is more vulnerable to those matters. This policy argument also rests on the misconception that a written conveyance necessarily provides certainty as to the boundary. Written conveyances are frequently vague. They frequently just use land registry plans or poor quality plans, poor scale plans from which an exact boundary cannot, in practice, be determined. Whilst a court, as a matter of principle, must be able to adjudicate and determine where a boundary is, it doesn't follow that original conveyances will necessarily assist. Moreover, original conveyances are frequently lost. They are not always available for inspection at land registry. The property might have been divided long before first registration. My Lord Justice Zacaroli last year, whilst a High Court judge, set on a case called Charlton and Forest, which my Lordship may remember, in which case there was no route conveyance, there were no contemporaneous plans of any assistance whatsoever, and the case had to be determined by reference to evidence. It seems from the judgment was relatively vague as to the existence of physical features at the time of the conveyance. Those are exactly the problems that are encountered in practice. There isn't a reliable repository of original conveyances. That then takes me to the third part of my submissions on precedent. In my skeleton argument at page 47, this is the core bundle. I identify in paragraph 26 and the subparagraphs 3 propositions about what a precedent, a binding precedent is. The first stage is identifying the ratio of the case, and then there's a second proposition about the court not being bound by propositions that are assumed or not subject to the argument, and then there's a third point about conflicting decisions of courts of coordinate jurisdiction. The first point is clarified overly from paragraph 27 by the meaning of necessary explained by Lord Justice Leggett in Young Sam. My lady sent to council yesterday through her clerk the Churchill and Merthyr Tydfil case, which endorses Lord Justice Leggett's decision in Young Sam. It's the same statement of principle, and those statements of principle are agreed as between the parties. There's one other point from Young Sam which may be relevant. I'm not quite sure how my learned friend put his case earlier, which is the judgment isn't in the authorities bundle because the principles are agreed. But paragraph 49 of Lord Justice Leggett's judgment says that where there are two routes to a conclusion, both of those routes form part of the ratio. So when we look at Nielsen and Poole, when Mr. Justice McGarry had two possible routes to the same outcome, both routes are part of the ratio. Otherwise, a case with two such routes would have no ratio whatsoever. Insofar as it suggested, therefore, that the conclusion in relation to the boundary agreement is not part of the ratio of Nielsen, that submission is wrong. Turning then to the application of the principles of precedent to the particular cases the court's attention has been drawn to. First of all, in Nielsen and Poole, Nielsen and Poole did involve a successor in title. The defendant, Poole, had bought at auction from the personal representatives of a Mr. Shorthouse, and it was the representatives of the estate, the public trustee, who had entered into the boundary agreement with Mr. Nielsen. So that it was a case involving successors in title. And the particular argument taken in that case was that Mr. Poole wasn't bound because the agreement wasn't registered as a land charge under the Land Charges Act 1925. Said it should have been registered as an estate contract. Now, the simple point I'll make without taking your lordships to the Land Charges Act is that the Land Charges Act is only concerned with the protection of purchasers. So it's only concerned with the position of successors in title. And therefore it must be part of the ratio of Nielsen that the defendant was bound even though he was a successor in title. Because the entire purpose of his argument in relation to boundary agreements related to the position of purchasers and their protection by the Land Charges Act. The judgment of Mr. Justice McGarry, though, is of course a High Court judgment, so it doesn't bind this court today. It is nonetheless persuasive for the reasons my Lord Sir Launcelot Henderson gave earlier in argument. The two cases which in my submission do bind this court are Burns and Morton and Stevenson and Johnson. They are both cases decided by the Court of Appeal. They both involved implied boundary agreements, although in my submission that doesn't matter. And they both involved a party who was a successor in title to the original parties to the agreement. In Burns and Morton, which is at tab 6, the new wall had been built before the Burns had bought their property. The arguments of the parties are recorded, first of all, at page 61, in the final paragraph on the page below H and the margin annotations.
Sorry, which page?
61 of the authorities bundle is the very bottom of that page. Mr. Kramer, who represented the defendant, submitted that building a wall by the defendant within the confines of his own property was not capable in law of transferring to the neighbouring owner a strip of land. Mr. Such, who represented the plaintiffs or claimants over on page 62, the first full paragraph on that page, his submissions are set out. And then, most importantly, his final submission, which starts around about D in the margin annotations. Then finally, relying on Nielsen and Poole, Mr. Such submits that there was an implied agreement between the parties that the new wall should be both a boundary wall and a party wall. On the same page at paragraph E, Lord Justice Swinton Thomas said that Mr. Such's submissions were well founded. Not only do his submissions, in my view, accord with principle, but also with authority and common sense. Lord Justice Swinton Thomas then goes to set out the head note of Nielsen and Poole, and at the very bottom of paragraph 62 identifies the holding, that is to say the proposition of law, which is relevant to this case. An agreement between the plaintiff and the defendant's predecessor, which was for a boundary along the purple line, was determinative of the boundary. Sorry, to paraphrase. The rule of law that boundary agreements bind successors in title is therefore identified. It must at the very least be an implied part of Lord Justice Swinton Thomas's reasoning that boundary agreements bind successors in title. Because even applying the narrow definition of a ratio prior to the clarification from Lord Justice Leggett and Young Sam, it's a logically necessary step in reaching his conclusion. If boundary agreements had not been binding on successors in title, the result of the case would have been the opposite.
It does look as if the point, though, that a boundary agreement can't bind successor in titles wasn't one that was argued.
Well, the particular argument that's taken is perhaps page 63 at B. Mr. Kramer sought to distinguish the case. And it seems that the basis for the distinction was that there was a small degree of alteration of the boundary. In effect, it's the same effort to distinguish the Nielsen principle in that's later seen in Joyce, that if there's a small disposition of land, a trivial disposition, it is not a boundary agreement within the doctrine. The exception, the second point in the principles, that a ratio of a case isn't binding if it's simply assumed without either argument or consideration, is a narrow exception which should be lightly invoked. In this case, the proposition of law is identified. The outcome would be necessarily different if that proposition hadn't applied. There's argument about whether or the extent of the Nielsen principle, and Nielsen is itself a case concerning successors in title. The second Court of Appeal case that I say is a binding precedent is Stevenson and Johnson, which appears at page 7 of the authorities bundle. That case again involved an implied boundary agreement, this time reached between a Mr. Vane, who was a predecessor in title of the Stevensons, and Mr. and Mrs. Johnson, who were parties to the implied agreement and parties to the litigation. The arguments of Mr. MacDonald QC for the Stevensons are recorded. The recording of them is, I accept, somewhat confusing or contradictory. If one looks at Mr. Justice Bennett's judgment, which appears relevant part at page 72, paragraph 40, the court records Mr. MacDonald's express disclaimer of any intention of inviting the court to clarify matters of law, and said that the sole issue is whether the judge had correctly drawn the right inferences from the primary facts when he found an implied agreement. But then at paragraph 41, his fundamental submission is recorded. His clients have a good paper title to the disputed land, and at the conclusion of that paragraph, the principles of adverse possession are in being to assist in sorting out problems relating to boundaries, and the court should not therefore strive to find agreements varying that which has been agreed in a conveyance. So, whilst ostensibly disavowing any attention to clarify the law, Mr. MacDonald, Queen's Counsel, appears to be adopting a line of argument very similar to the one adopted by Mr. Wilmshurst in this case, which is to say the original conveyance is determinative, the court should not look for boundary agreements, which would be, in my submission, a departure from the previous law, not a clarification of it. Similarly, in the judgment of Lord Justice Clark in the same case, page 75 of the authorities bundle at paragraph 60, is recorded near the end of the sideline passage. It is expressly accepted by Mr. MacDonald that if such an agreement is to be inferred, it has legal effect, although it's not said what that legal effect is. Then later at paragraphs, in Lord Justice Pill's judgment on the next page, paragraph 66, the fundamental submission previously identified by Mr. Justice Bennett is again recorded. Mr. MacDonald QC has forcefully argued that boundaries are formal and that it is fundamental that the relevant land was conveyed by a deed of gift in 1973. Mr. MacDonald submits that the law's mechanisms for dealing with a situation where boundaries are to depart from those which accord with conveyances is by way of the law relating to adverse possession. And at the end of that sentence, the court he submits should not strive to find agreements which conflict with paper title. The court should not be astute to replace the effect of the conveyance by the actions of the parties unless their intentions are clear. There's ambiguity, therefore, as to what exactly Mr. MacDonald QC's submissions were. In terms of the way that the court disposed of the appeal, at page 74, paragraph 57, which is at the bottom of the page, marked in the margin. So Mr. Justice Bennett decides that it's sufficient. Mr. Vane, the course of the parties' conduct, that is to say, Mr. Vane and the defendant should be looked at, and if, on the balance of probabilities, an agreement is established, that is sufficient. Then in the following paragraph, my finding of an agreement renders it unnecessary to move on to other grounds of appeal relating to estoppel. That would here in my submission to be a finding that the boundary agreement between the predecessor and one of the parties bound the successor without more. The rejection of Mr. MacDonald Queen's Counsel submissions that the conveyances are determinative. On page 75 at paragraph 64, Lord Justice Clark concludes his judgment by concluding that the judge was right to hold that there had been an agreement, and then said it follows that it represents the northern boundary of the property subsequently conveyed to the appellants by Sir Jocelyn and the personal representatives of Mr. Vane. I too would dismiss the appeal. So again, separate conclusions that there both was an agreement and that agreement was conclusive as to what was subsequently conveyed to the appellants. And then finally, Lord Justice Pill, at page 77, paragraph 70, in the third line of that paragraph, that boundary is not clear from the conveyances, in my judgment, and certainly not clear from the conveyance to the defendants. It is a similar situation to that existing in Nielsen and Poole, though in that case, Mr. Justice McGarry was confident in the view that the conveyed boundary coincided with the boundary agreed. He goes on to quote Mr. Justice McGarry, endorse his sentiments, and then in paragraph 72, is for those reasons, as well as those given by Mr. Justice Bennett, that the judge was entitled to conclude that Mr. Vane did agree the boundary which is now disputed by the claimants. I also agree with Mr. Justice Bennett that it is neither necessary nor appropriate to go on to deal with the estoppel argument raised. So again, the Lord Justice Hill's conclusion involves both the conclusion that the agreement was indeed reached, that the judge was entitled to find it, and that it bound successors in title, the current parties to the litigation.
And all three members of the court agreed there was no need to go on to look at estoppel. And that only makes sense on the footing that successors entitled are bound.
Without more.
Without
I think
more.
it's two of the three members expressly say they don't need to consider estoppel principles.
Well, Justice Clark begins his judgment by saying, I agree. So on the face of it, that implies...
yes, there's no suggestion there's a difference of
different
approach.
Well, anyway, a majority would do. I mean, if one's looking at it in very strict and formal terms.
It's, again, at least implicit in this judgment that boundary agreements bind successors in title, because otherwise it would be the opposite result. There was a apparent concession by Mr. MacDonald, Queen's Counsel, though a concession doesn't stop a case, a ratio being giving rise to a binding precedent. The court still needs to consider whether it was considered by the court, and in my submission, the position of successors was expressly considered in the Stevenson. Conscious to be efficient with my time and to give Ms. Cross some time to talk, I would just draw the court's attention to what I say are the two persuasive obiter judgments of this court without taking the court to them. They're cited in the skeleton argument. So the first is Haycox and Neville, which is tab 9 of the authorities bundle. The case did involve successors in title, but the boundary agreement hadn't been pleaded by the Haycox. And there's a very clear statement of law by Lord Justice Lawrence Collins, which you've seen this morning at paragraph 25, page 95. An agreement to demarcate an unclear boundary is binding on successors. It says entitled. I think it might be an error in transcription. Whilst obiter, that is about as clear a statement of principle as one could find. It's therefore persuasive. Equally, there's the case of Charalambous and Welding. That case again involved successors in title. On the facts, the agreement was found not to be an agreement about the boundary. It was an agreement about landscaping near to the boundary, but wasn't an agreement as to where the boundary was. But at page 99 of the bundle, paragraph 4, and also at page 100, paragraph 6, there's observations by Lord Justice Stanley Burnton that if it had been a boundary demarcation agreement, it would have bound successors in title. Then finally on Gibson and New, why that's not an authority. Obviously, it's not an authority that binds this court because it's a decision of the High Court. I say His Honour Judge Duddridge was right to conclude that it didn't bind him as a judge of the county court for the reasons that he gives in his judgment, which appear at page 75 of the core bundle. Starting at paragraph 53, I think. Sorry, bear with me 1 second. Sorry, 76 from 63 through to the conclusion of that passage at 68. Aside from any argument about whether the proposition that boundary agreements don't bind successors in title was or wasn't a necessary step in Mr. Justice Murray's reasoning, the fundamental reason why His Honour Judge Duddridge wasn't obliged to follow it is the third principle about binding precedent, which is when there's a conflict of two judgments of coordinate jurisdiction, in this case 2 High Court judgments, the judge is only obliged to follow the later judgment if it has given a full consideration to the earlier judgment. Mr. Justice Murray in New thought that he was following the judgment in Nielsen and Poole.
Sorry, he thought he was following Nielsen.
Yes, there's no indication in his judgment that he considered that he was departing from the principles in Nielsen and Poole. Nielsen and Poole does establish that boundary agreements do bind successors in title, and therefore to the extent that Mr. Justice Murray observed otherwise, he wasn't following what Nielsen and Poole had said, even though it appears from his judgment that he thought he was. For that reason, His Honour Judge Duddridge considered that Nielsen and Poole hadn't been fully considered, because if it had, that inconsistency wouldn't appear, and therefore he wasn't bound by it. In my submission, Mr. Justice Murray in Gibson and New elides the distinction that was drawn out by a question earlier, I think by my Lord Justice Zacaroli, that there's a distinction between a boundary agreement giving rise to a disposition of land and of a boundary agreement having a proprietary effect in that it affects the property rights of the parties. It is not a disposition of land, it's not a transfer of land, which is what is decided in Nielsen and Poole and all of the subsequent authorities of this court. What a boundary demarcation agreement does do is defines the land that the parties to it owns, and that agreement, allied to the route conveyance, binds subsequent owners of the land. It has a proprietary effect, even though it is not a proprietary disposition. Mr. Justice Murray was, of course, dealing with the effect of an agreement between the original parties to it, so it was not critical to his decision whether or not boundary agreements bound successors in title. Therefore, it's perhaps understandable why that distinction was not at the forefront of his mind. It didn't affect the outcome of the case. That takes me to the end of my part of this submissions. I ask Ms. Cross to address the court on the procedural questions relating to ground 2, the notice or knowledge ground. Unless any of my lords or my lady have any questions for me at this point, I will sit down.
No, thank you very much. Miss Cross?
I'm grateful, my lady. I will briefly set out the respondents' procedural objections to ground 2 of this appeal. Ground 2 being the ground that relates to the knowledge of the boundary agreement. The procedural issues I'm going to cover are raised in our skeleton argument, which is at pages 59 to 60 of the core bundle, and paragraphs 80 to 86. My lady, my lords, in my submission, the court should refuse to entertain ground 2 of the appellant's appeal for 2 reasons. The first is a matter of jurisdiction, and the second relates to the court's exercise of discretion. As your ladyship and your lordships have already observed this morning, the issue of the appellant's knowledge of this boundary agreement was not pleaded by the appellant. And I will return to that point in due course in relation to my arguments on discretion. My first submission, though, is that where this issue did not form part of the first appeal in these proceedings, this court has no jurisdiction to hear it on a second appeal. My lady, my lords, Section 54(4) of the Access to Justice Act 1999 is clear that no appeal may be made against a decision to give or refuse permission to appeal. That section appears in the authorities bundle at tab 27, page 263. My lady and my lords, whilst not expressly stated in the judgment of His Honour Judge Duddridge in the first appeal, the judge implicitly refused permission to appeal on the basis that is now set out in ground 2 of the second appeal, precisely because the point did not form part of that first appeal. If I may invite the court to turn to page 77 of the core bundle. At paragraph 72, the judge finds that the issue of knowledge was not referred to in the grounds of appeal and specifically did not form part of the criticism of the decision of District Judge Mills at first instance, which was set out in ground 5 of the first appeal. The judge notes that there was only a passing reference to the appellant's assertion of his lack of knowledge in the skeleton argument and prepared on his behalf for that first appeal. The judge decided that he could not decide ground 5 of the first appeal on this issue of law, since it was not set out in the grounds of appeal, nor, in fact, in the skeleton argument of the appeal, which only referred to the factual position as the appellant put it. My lady, my lords, in circumstances where His Honour Judge Duddridge granted permission to appeal on ground 5 only, and was clear that the issue of knowledge did not form part of that ground, or indeed any of the other grounds, the judge implicitly refused permission to appeal on this point. As a consequence, this court does not have jurisdiction to hear a second appeal on that issue. My lady, my lords, even if we are wrong about the point on jurisdiction, in my submission the court should nevertheless dismiss the appeal on ground 2 as a matter of discretion. In light of the principles recently restated by this court in the case of Ryan Shipping, DMCC and Vittle SA, which is at tab 13 of the authorities bundle, starting at page 159. In my submission, the appellant should not be allowed to raise this new point for the first time on a second appeal. For ease of reference, those principles are set out on pages 174 to 176 of the authorities bundle at paragraphs 23 to 31 of Lord Justice Popperwell's judgment. In respect of the principles, I first draw the court's attention to the principle set out on page 175 of the authorities bundle at paragraph 26, where Lord Justice Popperwell stated that it will usually be fatal to the new point being permitted to be raised for the first time on appeal if there is a real possibility that, had the point been taken at trial, evidence could have been adduced which might have affected the outcome. In the order granting permission to appeal, which appears page 3 of the core bundle, Lord Justice Snowden notes that the fact that the appellant had no knowledge of the boundary demarcation agreement was raised in the appellant's skeleton argument for trial. However, as my Lord Justice Zacaroli noted earlier, the issue was not pleaded in the defence, nor was it pleaded in the amended defence, which was attached to the appellant's unsuccessful application to amend his statement of case. That amended defence can be seen in the supplemental bundle at pages 45 to 52. The result of that, my lady, my lords, was that the respondents did not have the opportunity to address this issue in evidence. In my submission, this is not a pure point of law. It would be for the appellant to reduce evidence as to whether or not he knew about the boundary agreement. Now, as my learned friend took the court to earlier, the state of the appellant's knowledge is mentioned in the appellant's witness statement and also in the witness statement of Deborah White, both of which are in the supplemental bundle. The relevant pages are 13 and 25. But in my submission, my lords, my lady, Witness evidence of the appellant is not enough. Evidence about whether the appellant had constructive knowledge, for example, may have been adduced had this matter been part of the trial, part of the pleadings. Further, there is a real possibility that the respondents could and would have made reasonable inquiries into the state of the appellant's knowledge. For example, it might have been that they could have obtained further evidence from the predecessors in title and from the vendors of these parcels of land. And next, my lords, my lady, I draw attention to the principle stated in line shipping at paragraph 29, which is at page 176 of the authorities bundle. The principle is that it will usually be fatal if the new point requires findings of fact, which the judge has not made. It is clear that the judge made no findings of fact about what the appellant did or did not know about the boundary agreement in this case. And as Lord Justice Snowden notes in the order giving permission to appeal, the factual question of the state of the appellant's knowledge may have to be remitted to the district judge if ground 2 is decided in the appellant's favour. My ladies, my lords, I will finish by highlighting paragraph 30 of the Rhine shipping case, which in my submission neatly summarises the respondent's position. The judge, Lord Justice Popplewell states, in conducting litigation, the parties can be expected to address the facts which matter for the way in which the claim has been framed, and indeed the overriding objective requires them to do so. The issue of knowledge did not form part of the appellant's case at first instance, nor did it form part of the grounds of appeal at the appellant's first appeal. My lady, my lords, for all those reasons, the court is respectfully invited to dismiss the appeal on ground 2. Unless the may assist further with those matters.
Just one thing. What's said against you, I think, at least in part, is that, yes, this wasn't pleaded, but it was raised in the skeleton before the trial, and no objection was taken at that stage. What's the position on that?
My lord, as we heard earlier, due to the lack of court time, it was decided that the matter would proceed as a preliminary issue. And the primary case that was being advanced by the appellant at first instance was about whether and when the boundary agreement was made. And so that was the focus of the issue. No evidence was given by Mr. or Miss White, and so there was no cross-examination and no challenging of their witness evidence.
Implicit in that, I think, is that had this issue of knowledge been one that was to be determined, they would have been you would have required them to be called for cross-examination.
Indeed, but given that this issue of knowledge was not pleaded, it would not necessarily have been a point on which cross-examination would have been carried out, because it did not seem relevant to the issues at hand.
Could it perhaps also be said that, I mean, in a sense by accident, because the problem was just apparently lack of court time to deal with all the issues, but for whatever reason, the decision was taken, obviously not appealed, and no doubt very sensible, to deal with the preliminary issues first. And just for that reason, if no other, the knowledge issue went by default, whereas had it not gone by default, it might at least have been an opportunity for the defendant and all his advisors to make an application to amend so that the point could be raised in line with what he said in his witness statement, in which case there would have been a discretionary exercise for the trial judge to carry out, but for understandable reasons, of course, that didn't happen. It was just all put on the back burner, and everyone had to concentrate on the issues which we're now dealing with. So if that is right, then possibly it might seem a little unfair now to apply the full rigour of some of these principles, when it was really a case management decision to take preliminary issues first, which has really led us to where we are.
My lord, you're quite right that there were other factors at play at the time of the trial due to the lack of time. What I would remind the court of, though, is that the appellant had made a previous application to amend the statement of case, and at that point they could have included the knowledge point, and it was not included in that draft amended statement of case. So whether they might have come back to it later had it arisen later.
I see. So, sorry, what was the status of that application to amend? I mean, was it actually ruled on by anybody, or was it just something?
It was, my lord. It was dismissed. The application itself is in the supplemental bundle from page 40. I'm not sure we have.
I perhaps might assist because I was trial counsel for the respondents. It was ruled on, I think, by Mr. Recorder Gallagher, a hearing that took place a few weeks before the trial. So it was dealt with on the principles about late applications to amend and was dismissed because it didn't satisfy those principles. And then I believe an application for permission to appeal was refused by a High Court judge on that application.
Thank you. So the point is, there was an application to amend, it was dismissed, and in any event, the draft amended offence didn't deal with the knowledge issue at all. That's right.
Quite correct, my lord.
Thank you.
My lady, my lords, unless there are any further questions.
Thank you very much. Mr. Wilmshurst.
Yes. Dealing with Mr. Adams' point in short order. The example was given of when B sells to C, and then C sells to D, and D to E, and so on and so on. But what I would observe about this example is that the length of time which that might take might eventually reach 100 years. And is anyone seriously suggesting that in, say, 50 years or 60 years' time, somebody's going to say that there was a chat over a garden fence? It's in practical terms, even where these chats happen in the garden or whatever, they will disappear from human memory. And in such circumstances, the court will be dealing with this matter on the basis of if things have stayed, if the boundary has been respected throughout all those decades, and the deeds show something different, and somebody wants to start a boundary dispute, even despite that, then it will be the principle of adverse possession that applies. Or some probably adverse possession, because the memory of erecting the first fence in reliance on the agreement will disappear. And so in that way, it's entirely consistent with what Mr. Justice McGarry said in Nielsen and Poole, where he spoke about limitation. I would respectfully disagree that in that paragraph, Mr. Justice McGarry is talking about a Type 1 agreement, which is effectively where you just sell the land, because he in terms talks about demarcating agreements in that last page of, I think it's the last page, it's towards the end, it's the crucial page 53 of the overall bundle. Towards the end, 3/4 of the way down, a contract merely to demarcate and confirm is not a contract to convey. So he's in terms talking about demarcating contracts. There's nothing to be said for Mr. Justice Murray, in his judgment, did spend some time trying to distinguish between the two, but it's very clear that there's Type 2 agreements is what it's all about. It's not really about an agreement to transfer some land by executing a deed. My learned friend says that in a position where where you've got A and B who make the agreement, but B sells to C, that this could give rise to circumstances where A loses out, and that in effect would be wrong because it's out of A's control as to whether or not B tells C about the agreement. I think I've hopefully addressed that point already. That it's a case of all of the cards are already stacked in favour of A and B. That they have, then there are things that they could do to mitigate that risk at the land registry. Or I suppose they could agree between them that that B should tell C or A should tell whoever they sell to, and then the law will prevent unconscionability, and the law will reflect a long adhered to boundary. So in practical terms, although I accept that A could not have the benefit in theory of the agreement, in practical terms, and of course, my lord, you mentioned this Justice McGarry as having, I think my learned friend mentioned, he had a great practical experience of these disputes. My submission here is, in practical terms, actually it's extremely unlikely that A would lose out. It's only in circumstances such as these, where A and B have made an agreement and then both sold immediately without doing anything, that A would lose out, which is the respondents. But that is not a conclusion or result which should offend the court, given the overall way in which it would normally operate in practice. In terms of, I think my learned friend mentioned about the contractual nature of a boundary agreement, and but it nevertheless affects the extent of the demise in his submission. I do submit that there isn't really another example of where a contract between A and B can affect things outside of A and B's relationship. That it is always spoken of as a contract, so that a deed inter partes, for example, doesn't usually have an effect in rem. A contract between two people having an effect on the whole world is an unusual concept. One which doesn't fit well with Mr. Justice McGarry's justification in principle for the boundary agreements. And I do urge you to I accept that Mr. Justice McGarry was very experienced High Court judge who was renowned for his expertise in real property. And so I urge you, therefore, not to conclude that where he specifically gave a justification for boundary agreements operating by limitation, that was a throwaway comment, because it seems to be quite integral, my submission, to the overall analysis. And then my learned friend took you to where Mr. Justice McGarry was talking about or he cited Penn versus Lord Baltimore, because it's not where Lord Hardwicke said, in the context of that very different case about the governmental boundaries of the two petty kings of North America, that it was not an alienation of land, but it was the true and ancient limits. But really, is that the principle, I would ask, that Mr. Justice McGarry was actually applying? Because in my submission, the actual principle he's applying is using his own words in the judgment in that paragraph. Of course, if the boundary is the same on the face of the deeds, that the parties happen to agree, then limitation has no place. But if it happens to be different, then it will apply. And if it is uncertain whether that's the case, then reliance will have to be made on limitation to give the result which is required. And of course, in passing, I note that, of course, in Joyce, Lady Justice Harden talks about de minimis, but yes, if the underlying justification is going back to Mr. Justice McGarry, and his reliance on Penn and Baltimore, talking about the boundaries of Pennsylvania and Maryland. Well, I talk about huge areas. It seems that there's a very large disconnect between the underlying principle and the state of the law as it has arrived. My learned friend also submits that effectively Mr. White's submissions will lead to great uncertainty. I do refer you back to Mr. Watt's excellent article, which of course argues the reverse, that the boundary agreement, the law on boundary agreements is in danger of creating what he calls doubt hold. And of course, if it is the case now, following Joyce, as my learned friend very clearly outlined, that we have the question of de minimis, and then we have the question of whether or not the subjective purpose of the parties was to demarcate, you have some criteria that the court, as my learned friend mentioned, can adjudicate on, but all the time. So this itself is in danger of creating doubt, because instead of certainty, you have a position where the subjective intentions of the parties who made the agreement could be called into question, analysed in evidence 10 or 20 years after the agreement was made, which doesn't sound, my respectful submission, to be something that leads to a great deal of certainty. My learned friend helpfully took you to Roof and Roper, and I think it does, the paragraph he took you to, actually that last paragraph, does mention the form of notice that I referred to, which I couldn't quite find the justification for. It doesn't provide the statutory basis for it. I don't know whether the court wants that. It just talks about the form that's used. Thank you. And so I've already addressed Stevenson and Burns, so I don't need to reply in respect of that. I turn then finally to reply briefly to the procedural points. Firstly, I would just emphasise again the very peculiar circumstances of the trial itself. It was quite clear when we arrived at court that insufficient time had been allowed, and that was even without the difficulty of Mr. White having to pause to give evidence if he was going to give evidence. So there was an arrangement, as it were, that was arrived at to try and make use of this time to deal with the question of the boundary agreement and its validity. And that question revolves around the conveyancing material, because it's clear from the district judge's judgment, as he records, that there was communications between conveyancing solicitors for the Alders and their predecessors in title. He also records that, although not complete, he had some conveyancing material from my clients. I mean, it is obviously clear that when people buy and sell property and they do so through solicitors, that the knowledge that they have about any particular thing is a matter of written record, because that's how conveyancing works. It's never been identified particularly how there is any unfairness in what occurred, or how it could possibly be said that Mr. White did have some knowledge. That was not articulated, has never really been articulated. I think it was said that it was said that there could have been investigations in relation to Mr. White's vendor. Well, there was some written emails from the vendor, but seeing as that you'll see in the amended case that wasn't permitted, you'll see from that the proposed amendment was to say that it had been fraudulently, the paper document, Appendix C that you have here, which is forming the boundary agreement, was fabricated by Mr. James, i.e. the predecessor in title to the Alders. So, be as it may, it proceeded on the basis that none of those arguments were going to be allowed. But it's certainly not the case that there was some kind of surprise. On the 28th of May 2021, that's the Mr. White's witness statement was provided. Witness statements were provided, and as you can see from the supplemental boundary, it states in terms that he had absolutely no knowledge of this until Mrs. Alder told him and his wife, Mrs. White, about it in 2016. There are paragraph after paragraph of very clear explanation. So when it was put into the skeleton argument before the district judge, bearing in mind also that it was a district judge that I was addressing, and I was necessarily constrained to describe that in terms of the most recent High Court decision. No objection was taken to it, even though it had been agreed that the validity of that boundary agreement was going to be the subject of this very shortened fast-track hearing, with a procedure just adopted to try and make use of the day. So that was the 18th of July 2022 when the respondents received my skeleton argument for trial. So then it was orally ventilated before the district judge. He doesn't deal with that point in his judgment, as I say, because it's considered that he seemed to say that it was just binding full stop, as the interpretation goes. It was then argued at the first appeal hearing on the 29th of September 2023. So it's not exactly a surprise that this point is being taken, and Lord Justice Snowden, having granted permission, I would respectfully submit that the submissions of the respondent can't go so far as to actually challenge the decision on permission, where Lord Justice Snowden already considered whether the point was put and considered the skeleton argument that was before the district judge, although expressed some initial concern about whether or not how the court would dispose of it if it found in favour of Mr. White on the principle of law. I've said that the pleadings were the pleadings, notwithstanding any proposed amendment. No admission was made, because the whole point of those was that there wasn't really a boundary agreement. I suppose it's a bit like if there's an easement case and you don't expressly deny each and every. Well, of course, it would never be part of the. It should, I suppose, if there is a knowledge requirement, then I would suggest that it's for the claimant to prove the knowledge, because it's an element of showing that there is a binding boundary agreement. So, obviously, it being that wasn't in the particulars, But the response to that is not to concede that somehow, as a matter of fact, it was known about. So that being no concession, the claimant in my submission would need to prove it. But that's supplanted by the fact that there was no objection taken to the course. So in my submission, the pleadings point is a non-starter because of what happened at the trial. And then on appeal, again, it was orally ventilated, and because the ground of appeal before the circuit judge was that Mr. Justice Murray's decision was binding, it was wrong to regard it as an obiter dictum. If the circuit judge had actually found in favour of Mr. White at that stage, he would have had to have considered what the effect of that judgment was, and before the district judge, which of course that skeleton was before the circuit judge and was used as part of the appeal. It was clear enough that was being argued. It's not, as it were, unspoken. At no stage was it unspoken. It was continually pressed at every stage that was possible. And then when His Honour Judge Duddridge did not adequately, or in my respectful consideration, deal with that point, I wrote to him, and then he added on to the end of that judgment some further information about that. So, however, my learned friend mentioned, of course, this Rhine shipping case, and the requirements are set out just at paragraph 23 if there's a new point to be argued on appeal, which of course I don't accept. But the first test in that is, from paragraph 23, is whether or not, first, an appellate court will be cautious against allowing a new point to be raised on appeal that was not raised before the first instance court. Nowhere does it say anything about pleadings in paragraph 23 of Rhine shipping, only talks about raising. So that requirement would be met both by way of the skeleton argument and the very, very clear witness statements. Secondly, if the point would necessitate new evidence, then it would not generally be allowed to raise a new point. But here, as I've outlined, there can't possibly be, in the context of two conveyancing files from transactions conducted by solicitors, that there going to be no evidence. And the district judge has already found at paragraph 19 that Mr. White's vendors gave him a property questionnaire which said that there was no dispute at all as of August 2005, just a few months before apparently there's meant to be a dispute and it's been settled by way of boundary agreement. So that having been said, it's not as if anyone can give. It's unclear whether there's there's no evidence to support the notion that Mr. White would have known. How would he have known? Then it says in Rhine shipping that the trial would have been conducted differently with regards to the evidence. And that's the agreement was that the witness statements of the Whites were before the court. That was agreed. It wasn't that they weren't put into evidence, it was just that a pragmatic course was adopted. So it being clearly flagged and argued, and that agreement being reached as to how to proceed, it's difficult for the respondents to submit that they would have taken some different course. To the extent that that's submitted, it is my respectful submission a retrospective analysis at the point of a second appeal, trying to support a procedural objection to this important issue being determined. And then, thirdly, in Rhine shipping, there's a question of whether or not the parties have adequate time to deal with the point. Well, there's no difficulty about that. There's been every opportunity given to take it, and we've had full argument on the point today. So, then there's the requirement that the other party's not acted to his detriment on the faith of the earlier admission to raise it. Well, that doesn't arise because it was raised. And then finally, even then, there's a consideration as to whether or not there can be protection and costs. Well, there could be, in theory, protection and costs, but I don't concede that. But, I mean, obviously, the court can reflect anything it likes in costs. So these are all the points on the court permitting a new point to be raised. But as I say, so even if it were to be considered to be new, it's not new, shiny new. And in those circumstances, even if the court was to consider that there was some procedural defect, then it should allow the point to proceed. There's clearly also a great public benefit in the court, as identified by Lord Justice Snowdon in giving a clear ruling on these important issues. So, unless my lady or my lords, you have any further issues?
I'd just like to ask whether you've got anything to say about Ms. Cross's first heading, which was jurisdiction, as a result of Section 54, subsection 4 of the Access to Justice Act.
Did I say that obviously the grant?
That's just my fault. Perhaps I missed what you said.
The grant of permission can't be challenged by saying that effectively we're going to undo the grant of permission, I think is my submission on that. And Lord Justice Snowdon considered this very point. So there's a judicial analysis and a judicial consideration as to whether or not this was something that should be knocked out, not granted permission for that reason. It's clearly undesirable to sort of go over the go backwards in time, otherwise the court's never going to be able to deal with things.
Sorry, I may have got the wrong end of the stick. I thought the point which Ms. Cross was making was that permission to appeal had implicitly been refused by the district judge. It was that previous point, that previous stage.
Well, obviously Lord Justice Snowdon didn't take that view when he granted permission.
All he's decided is that you've been able to argue the point before us today. I don't think he was preempting the outcome of the point.
No, but my submission, I think, would be that...
I mean, there wasn't an oral hearing before Lord Justice Snowdon. His order records it was made without an oral hearing.
So that would be a submission, effectively, that when Lord Justice Snowdon granted permission, that he had no jurisdiction to do so, because the circuit judge had implicitly refused permission.
I thought, maybe nothing really turns on it. I thought he was really just saying, well, I'm going to give you permission to raise the point before the full court, but without express. Obviously, he wouldn't rule on it then and there, because and I don't think he purported to do so. He just made some observations about what would follow if you were to succeed in persuading this court that you are able to take the point and you succeed on it.
Yes, of course. I mean, it's no observation on the merits other than that. But my point is that the learned judge says that since it would appear the appellant did assert in his skeleton for trial that he had no knowledge of the boundary agreement prior to acquiring Willow Cottage, but the district judge did not decide whether or not this was so given his view of the law, which is the point I was making to my Lord Justice Zacaroli, is that he seemed to treat it as though boundary agreements are binding on successors full stop, even though he'd had the submissions made to him about knowledge, which is ground two.
Ms. Cross is Ms. Cross is right that there is no jurisdiction for a second appeal if we're to construe the circuit judge's decision as effectively, or at least implicitly, denying permission to appeal on that point. There can be no further appeal. If that's right, and the point wasn't raised or argued before Lord Justice Snowden, he can't have conferred jurisdiction on himself, can he?
There was written submissions
on the question of jurisdiction.
There was. What we don't have, I don't think, is the respondents' written submissions. All that we have in the bundle is the my response, which is in the supplementary. But there was, my learned friend made written submissions on this, if I recall correctly, which we can provide to you, of course.
But your response doesn't go to this point at all, does it?
Well, the point was...
Oh, it says, your paragraph 1 says, respondent says that ground 2 is a new point. That's not correct.
Yes. See attached. What does it say? See attached. In any case, it was attached. The appellant's skeleton argument. Please see paragraph 8 of the skeleton argument before the district judge, and then that was attached. And then that's what led Lord Justice Snowden to make the ruling on permission, where he says it seems that it was raised. But what you don't have is the respondent submissions before I put this brief response submission in. So there was a judicial process of considering the issue, albeit on permission. But of course, the circuit judge does say, I mean, if it's perhaps, in my respectful submission, a little bit too much of a stretch to say that a circuit judge is implicitly not granted permission, especially where he expressly says at the end of that little postscript that it will be for other people to decide whether there's any, I think he says something along the lines of from memory, that it'll be for others to decide whether there's any merit at this point. That must be at page 88 of the bundle. No, not 88. 77. Whether this issue may be subject to a second appeal is, of course, a matter for a different court. I mean, that's inconsistent with implicitly refusing permission. And he says in terms that he's granting, well, that's the issue. So he expressly says that it could go further, and that's inconsistent with implicitly refusing permission. In both cases, oral argument was addressed to both judges, but it seems to have not been reflected in the judgments. But it's not the case that, as it were, there's just silence. I mean, it wasn't an afterthought. My lady, I think we could would you like the respondent submissions that led to my submissions on that, or
if it helps, I have copies to hand.
Well, please don't just pass them on. That's fine.
There you go.
oh, thank you.
It's the 3-page statement under paragraph 19 of Practice Direction 53C.
Thank you.
But it's not made as a point expressly in terms of jurisdiction. It just said this is it wasn't raised on first appeal at paragraph 8 and the subparagraphs 8.1 and 8.2. And just so we're absolutely clear about what the respondents are saying on this point, is that Lord Justice Snowden cannot confer jurisdiction on the court by a grant of permission that the court doesn't have. So if the circuit judge on first appeal did implicitly refuse permission to argue the notice or knowledge point, this court has no jurisdiction, and a grant of permission cannot create jurisdiction.
Thank you. Thank you very much indeed to everyone who has spoken and those who have done lots of preparation behind. We will reserve our judgments on this very interesting and difficult issue. As you'll probably all be aware, we circulate drafts of our judgments. It's important that those are only circulated to people who are within the ring, if I put it that way, whose email addresses have already been supplied. Be very careful not to share it with others who should not receive it, because we take that very seriously. Also, as you will be very well aware, we are grateful for your careful eye in relation to our errors of punctuation, etc., and matters of that kind. But please don't try to re-argue the case in any way, just to correct our obvious mistakes and to submit those corrections to our clerks. And also, as you will finally be also aware, we hope that you will be able, in the end, to agree an order if for all consequential matters. If you cannot, please provide very short written submissions on the points that cannot be agreed, and I mean very short, and they will be dealt with on the papers. Thank you very much indeed.
My lady, just one thing you've reminded me. Mrs. White is not a party.
No.
Could I have permission to send the judgment to Mrs. White as well?
Well, I'm not sure why she isn't a party.
She's not a registered owner.
No longer. Or was she ever?
Never.
No.
No.
It was because they took us to court before I got a chance.
Yes, that's fine. You can also let Mrs. White see it.
Thank you.
Thank you.
All rise.